Hello. The Divine Code reading for January 8th, pages 429 and 430. We are in the chapter Laws of Intentional and Unintentional Killing and Killing Through Negligence or Duress. Topic number 3. It has been previously explained in Chapter 1, Topic 24, that if one intends to kill a particular person, and then a different person happens to stand in the first person's place and is killed instead, or if one throws a stone into a crowd of people and kills any one of them, both of these are murderers and are liable for capital punishment by a court if convicted. Therefore, it is logical that even if the second person came and unexpectedly took the place of the intended victim, the one who threw the stone is equally responsible, since the first action that was taken was one of intent for murder, and therefore he is liable to the death penalty from a court. Tractate on Miri on Tractate Malkut, page 9. Regarding the Torah law for Gentiles, any case in which an action starts off with negligence is judged as negligence, even if it finishes with unavoidable results. So the person had intention. He did something with the intention. He did the action with the intention, and the action caused someone's death. In that case, these are the necessary steps. That he mistakenly killed the wrong person, or he did not intend to kill that particular person, but he had intention to kill. He did the action, and someone died. Those are the necessary elements to be considered murder. And whether he intended that particular person to die would be irrelevant at that point. Topic number 4. In chapter 1, it is explained that one who kills intentionally, either directly or indirectly, is a murderer. These two cases are likewise equal for unintentional murder. If one kills directly or indirectly by an act that is considered close to being intentional, he is liable to capital punishment by the court. If the act is completely unintentional, whether killing directly or indirectly, the manslayer is exempt from the court penalty, though the Torah's permission for the blood redeemer applies. So if it's intentional or close to intentional, so the person that throws it in, that shoots an arrow into a crowd of people, he intends to kill somebody, not particularly a specific person, though. So whoever he kills, that may be considered, it's close to intentional, and therefore that would be handled by the court. If the person is not intending to kill someone, he's shooting an arrow into a field that he didn't check to see if anyone's there. So his negligence on his part, that would be the unintentional. Now, if a sequence of events that if he did check the field and he made every reasonable effort, he put signs up and fencing and all that, and someone happened to jump over the fence and he wasn't aware of it, and the person gets shot by the arrow, that would be a complete mistake, a complete accident. The person would not be from the blood redeemer in that case. But if it's unintentional but negligent, then the blood redeemer would apply in that case. And the area of blood redeemer is complicated enough that it probably would require at some point a third party, that's a court, would have to make a determination that the blood redeemer can go after the person. Otherwise, we would have chaos and vigilantism, and we don't want that. So somebody, a third party, an impartial third party, would have to make the determination as to whether or not the blood redeemer would be able to go after the unintentional killer. Therefore, if one's actions directly cause a person's death, such as one who ties up a person and then places him in the sun to die of heat stroke, or leaves him to die of hunger, and even if he only intended to make the person suffer, it is considered bordering on intentional murder. So the person was shooting an arrow intending to injure the person, not trying to kill the person. But he was shooting an arrow at someone on purpose. That would be considered close to, the category of close to intentional, and the person would be liable in that case. Even if the perpetrator forgot to tie up the victim, who subsequently died. So the victim may have, if he had the wits about him, may have been able to get away, but for whatever reason, he didn't get away. And the person was intending to make the person suffer. Or the person shoots an arrow at someone who could jump out of the way if he was totally aware of what was going on. But the guy's not totally aware of what's going on. He doesn't jump out of the way because it happens so fast. And the arrow killed the person that could have jumped out of the way. That would be close to intentional murder, and the person would be liable. Therefore, the perpetrator is liable like one who committed intentional murder. Likewise, if the perpetrator tied up the victim with the intention to kill him by starvation, and then was prevented from saving the victim who subsequently died, he is considered in court as a murderer since it was his original intention, although circumstances occurred that kept it from being prevented. Murion Tractate Malkut 9, page 9. So in this case, the person ties someone up in a place where the person would die, or he shoots an arrow at someone. And he then, before the person dies, he has regret. So he has regret and he tries to save the person's life, but he's not able to save the person's life. The wild animal is too close, or something happens. He's not able to, even though he has regret, he's not able to get back in time to save the person's life. The fact that he had regret does not negate the liability in court. He is still liable in court for that death because that was his intention with the action, was to cause the death, and the person died. Therefore, the three necessary elements are there, and the fact that he has regret might help his soul, but he's still liable in court. However, if there was no intent for murder, but rather only to cause suffering, and he was subsequently prevented from untying the victim who then died, this is comparable to unintentional murder, and the court does not give a sentence of the death penalty. In this case, the Torah's permission for the blood redeemer still applies. So the person had the intent, he did not have the intention to kill. He ties the person up to make the person suffer. And something happens that he's not able to untie the person when he originally intended to untie the person at a particular point in time. He's not able to do that, and the person dies. That would not be considered intentional murder. that would be considered a highly negligent killing. And the blood redeemer would have those rules would apply, and whatever the court system. I mean, any civilized country is going to have a court system that would be functioning at that point. If one tied up a person in a public area where the tide will usually rise and cover the person, or where lions are plentiful in the area and there is a significant chance that they will find and kill the victim, and the person dies from these predictable circumstances, even if the perpetrator merely did not take the necessary precautions to avoid the lethal situation, and even if he did not know these dangers were there, this is considered close to intentional murder, for which he is liable for the capital punishment. In this case, it's close. I'm not sure if this would be by what logic this would be considered liability in a court of law. It is close, but it's a highly negligent action on his part. He did not intend to kill the victim. If he knew that there was a possibility of this happening, if he knew that the tide would rise, if he didn't get back in 6 hours, the victim would die, and if he knew that there are lions that could jump up at any moment, if he knew these things, then he knew there was a possibility the guy was going to die by his action, then that might be close to intentional murder. This category called close to intentional murder. If he was not aware, he just tied the guy up on the side of the beach without being aware of the tidal situation. He thought it was a lake, and it turns out to be the ocean. And he wasn't aware that the amount of tide that would come in at that place, at that location, that would be gross negligence and would be under the jurisdiction of the blood redeemer and the courts to determine how to handle that. If he knew that there was a reasonable possibility the person would die, then by his action, then that would be close to intentional murder, and that would the court would apply. So it probably needs to be distinguished a little bit more clearly in the divine code what it is we're talking about in this instance. However, consider the case of a person who was tied up in an area where lethal circumstances might happen, but the perpetrator was depending on conditions would be as usual, and the danger would not occur. So you're tying up the person in a location where there might be lions, but there really is no reason to think that there are lions, even though it's a possibility there could be lions. It's expected that there would not be lions at that location. If the lethal circumstances did happen and they caused the victim's death, then the one who bound the victim and left him is considered as having committed a lethal action completely unintentionally, and the court should not sentence him to capital punishment. The Torah's permission for a blood redeemer still applies, since the death is not considered unpreventable, was not unpreventable, and the actions led directly to his death. So, that would be a case where if the person ties up someone where there's a bunch of lions, and he knew there's a bunch of lions, then that would be gross negligence on his part. It would be close to. It wouldn't even be gross negligence. It would be close to intentional murder because he knew there was a strong chance that that would happen, and he did the action anyway. Therefore, in his mind, he knew that there was a 80% chance or whatever the person would be dead. In the case where there's an 80% chance a person would still be alive, that would be considered negligence or gross negligence on his part to have tied the person up, where it's a possibility he could have died, and he did in fact die. The victim does die. Then he would be under the category of negligence, and that would be the blood redeemer or the court system, depending on how civilized the society is. They have a court system that deals with these issues. Minhag Kinok Commandment 410, Part 9 states, if a ger toshav ties up a person before a lion, which is indirect murder, or in the case in which he is accidentally killed, he should go into exile. I'm not sure how the Minhag Kinok is determining here that the indirect murder would be an exile. Apparently there's difference of opinion between different rabbis as to how that would play out, whether the indirect murder would be a liability before a court, or if it would be a issue for exile. See Rambam, Laws of Murderers 5:9, who writes that an accidental murderer did not need to go into exile if the victim did not die right away, because it is possible that some other cause brought about death, based on Tractate Gittin 70b and Tosafot there. It appears that the reference is to a Jew who in this case would not have had to be exiled, and the point being made is that the blood redeemer has no permission to kill him. So if it's a case of a Jew killing a ger toshav, the rules are different, and it's more lenient on the side of the Jew. In that case, the Jew would not be fully exempt, but it would be more on a lenient side. The assumption is that the intention was not to kill. That's the assumption. It appears that for Gentiles, the blood redeemer has permission to kill the murderer, since a Gentile who murders intentionally, even through an indirect act, is liable to the death penalty. See chapter 1. Okay, so where earlier the Minhag Kinok was referring to, it may have been a reference to the Jew indirectly killing a non-Jew. Would not be the same as for the Noahide in the Noahide law. So that's what's being suggested here in the footnote. Since a Gentile who murders intentionally, even though through an indirect act, is liable to the death penalty, see chapter 1, and therefore the same law should apply for an unintentional murderer, he needs to go into exile, and the blood redeemer has permission to kill him, except for a ger toshav in a city of refuge. So in the case of the mistake, the gross negligence indirect murder, that's the case where the person is tied up in a field where there might be lions. There's possibility there's lions. And a lion happens to come across them and kills them. That's an indirect, negligent homicide, and the blood redeemer would apply. However, it's set up through either the Israeli judicial system for the Ger Toshav, or for a nation, for someone living in the nations. However, the legal system is set up to allow for the blood redeemer. Thank you.